CR0229.
versus
State versus Jesse Arriaga. Can I have parties announced for the record for the state?
For the state of Texas.
Defense.
And are you Jesse Arriaga?
And are you Jesse Arriaga?
Counsel, have you received
Counsel, have you received all discovery? Did you review it with your client?
Court will
Yes,
find
ma'am.
that the state
Court
is
will
in
find that the state is in compliance with discovery.
Mr.
Mr. Arriaga, did you review the document entitled Application for Deferred Adjudication with your attorney? Did you understand it?
Yes, ma'am.
Did you review the true
Did you review the true bill of indictment with your attorney? Did you understand it?
I did, yes, ma'am.
Counsel, do you waive reading?
Counsel, do you waive reading of the indictment?
Did you,
State,
Judge?
are you proceeding
State, are you proceeding on the indictment as presented?
We are not, Your Honor. We are proceeding forward on amended count one of attempted indecency of the child by contact.
Any objection?
Any objection?
We will waive count.
Any objection?
Any objection?
No, Your Honor.
All right, did you review the
All right,
document?
did you review the document entitled Court Admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Did you understand your
Did you understand you're charged?
Well, the state is proceeding
Well,
on
the
the
state is proceeding on the lesser included offense of attempted indecency with its contact as a third degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to $10,000 fine. Did you understand?
If you have to plea bargain,
If you have to plea bargain, yes.
I forgot to also include the amendment. I asked that Your Honor, reaching amendment, also known as the name Jesse Arriaga. Yes, sir.
all right, any objection?
All right, any objection?
No, Judge.
And are you
And are you Jesus
Arriaga?
Arriaga?
And are
Yes,
you
ma'am.
the same?
And are you the same person that is listed in the indictment?
Yes, ma'am. Yes, ma'am.
And do you also?
And do you
go by
also
the name?
go by the name Jesse
Arriaga?
Arriaga?
Not Jesse R. Not Jesse R. Jesse
sorry,
A.
Jesse A.
I'm sorry,
Arriaga.
Jesse A. Arriaga. Is that also you?
And
Yes,
you're
ma'am.
also.
And you're also Jesus
Arizola
Arizola Arriaga the third?
Yes, ma'am.
All right.
So, did you understand the range?
Did you
of
understand the
punishment?
range of punishment?
Yes, ma'am.
If you have a plea with the state,
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you took a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
All right, off the record.
All right, off the
I see
record.
here where you
I
all
see here where you all
put
state recommends deferred adjudication for a period of 2 years.
You are not allowed to
You are not allowed to enter into an agreement on the
of
length
probation.
of
So
probation.
that's a deal
So
breaker.
that's a
then.
deal breaker then.
We had an extensive conversation on that, Judge. We understand it's within the court's purview to set the
Then
term,
if-
although
Although
I think we can still agree to whatever we want.
All right, so.
All right,
What I would say is, what I would say is if this was find the court,
Well,
I wanted to have the ability to withdraw my plea if the court was not gonna follow that recommendation.
You all are not allowed
You all are not allowed to agree to the term, and it says the state recommends deferred adjudication for a period of 2 years.
That shouldn't be here.
That shouldn't be
If
here.
you all want to
If
put
you all want to put down here, this is where your recommendation for 2 years is, but not above the line. So if
Y'all are trying to bind.
y'all are trying to bind the court to the length of probation,
I'm not going to allow y'all to
I'm
do
not
that.
going to allow y'all to do that.
That was not the state's intention, Your Honor. Both parties understood that the court has the ability to, and to order however long the probation report deems appropriate. However, I think defense's concern was that we just wanted it to know that our state was recommending 2 years.
No, I mean, for the court,
It's there at the bottom of the line, and if you all want to argue and fight for 2 years on the record, you can, but placing it above the line is not appropriate for the court.
I understand, Judge. I understand, Judge. I'm not gonna quarrel. I expected you to say something along those lines. However, my position was, we wanted to be able to withdraw our plea if the court wasn't going to follow
So
it.
you all want me to
So
say
you all want me to say 2 years, and I'm telling you right now, you all don't get to
dictate or
make an agreement
to the length
to
of
the length of his probation if I follow the plea. And I know that's not anyone's intention, but it just should not be
above the line.
above the line. Because this is what's binding upon the
Well,
court.
this is the last thing I'll say about it, Judge. I'm not arguing with anything you're saying. The issue is, if I make certain representation to my client that induce him to accept a plea agreement, I don't want the rug to be pulled out from under him, because then he winds up with a 10-year probation instead of a 2-year probation. So I didn't know any other way to address that other than in this fashion.
All right.
In this fashion.
All right, so this is what I can tell you, sir.
The state and the
The
defense
state and the defense are not allowed to present the court and make it binding on the court that I were to give you a probation term of 2 years.
They can argue.
They can argue for the length of probation time. They can argue for certain conditions.
The only plea
The only plea bargain agreement you're able to enter into as a binding contract with the state is
whether or not
whether or not they're in agreement to you having deferred.
If they agree for you
If they agree for you to have deferred, hypothetically, we can go off the record. Hypothetically, if they were to agree for you to have
and then
deferred,
you come to me
and then you come to me and I say, I'm not giving you deferred, I'm giving you a conviction, then I have not followed your plea bargain agreement.
If they
If they were to say,
I want you to have
3 years in prison, and that's your
and then I
agreement.
were to come back
And then I were to come back and say, I'm not giving you 3 years in prison, I'm accepting your plea and I'm giving you 4, or I'm giving you more than that. I'm not allowed to do that because that's not a part of your plea bargain agreement. The length of time someone is on probation, that's for the court to decide. Whatever conditions, that's for the court to decide. For example, when you hear me telling people you to report every month,
If I were to tell
probation,
they can report once every 6 months,
once every 6
then
months,
those are my conditions.
then those are my conditions.
And they only have
And
to
they
report
only have to report once every
Do you
6
understand?
months. Do you understand?
So
Yes, ma'am.
So, the state
and the defense
and the defense are telling
that they
me
want you to have
that they want you to have 2 years probation.
the length of time.
The length of time.
They can argue for
They
that.
can argue
but
for
I don't
that,
have to
but
give
I don't
you
have to give
2
you
years.
2 years.
I can look at it.
I can look at it. Maybe I will give 2 years. I don't know. I don't know anything about this case. I don't know the facts of the
I could
case.
give you 3 years.
I could give you 3
4
years. I could give you 4
I could give you
years.
up to
I could
10
give you
years
up to 10 years probation.
I don't know
because I don't know anything about your
But they
case.
can argue.
But they can argue and say they want you to only have 2 years deferred. Do you understand?
All right. So if y'all want to
All right, so if y'all want to step back and discuss that, you can step back to
If you
discuss
still
it.
want to go,
If you still want to go forward with your plea bargain agreement, then this, for a period of 2 years that's initial, need to be removed from above the line.
Judge, we can scratch it. Judge, we can scratch it out, Judge.
All right. So if
All right, so if you all want to,
all right, we're back on the
all right, we're back on the record.
with regards to
So with regards to the plea bargain
is
agreement,
there any
is there any objection from the state or the defense, thank you, to the court removing the words for a period of 2 years
next to
the state recommends deferred adjudication?
We do not, Judge. We do
All
not,
right,
Judge.
so the court
All right, so the court will remove that portion.
and
And
Mr. Arriaga,
do you have any objection to the court removing that? All right.
No, I don't.
All right.
So you understand the
So
range.
you
of
understand the
punishment,
range of punishment,
and you understand that if
and you understand that if you have a plea bargain agreement, the court does not have to follow your plea.
If the court does not
If
follow
the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Do you understand?
You have a right to jury
You have a right to jury trial, a right for you or your attorney to cross-examine any witnesses the state will call and the right to remain silent. Do you understand?
By entering this plea.
By entering this plea, you are giving up those rights. Do you understand?
Do you understand?
Do you understand?
If the court were to grant your application for deferred adjudication,
if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in the prison and up to $10,000 fine. Did you understand?
Counselors, your client
been able to provide you with any
Yes.
defenses?
Do you believe
Yes.
he has a
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, Your Honor.
Do you
believe he's
currently competent and was legally sane at the time of the offense?
I do,
Mr.
Judge.
Arriaga,
Has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
Has anyone
No.
promised you
Has anyone promised you anything other than the
Are
plea?
you satisfied with the
Are
way
you satisfied with the way you've been represented?
Are you a U.S.
Yes, ma'am.
citizen?
Are you a U.S. citizen?
Court will
Yes,
find
ma'am.
that
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
According
Yes,
to the
ma'am.
plea,
According to the plea, the state is proceeding on the lesser included offense under count 1 of attempted indecency with a child by contact.
There's a $1,500
There's a $1,500 fine.
The state is recommending.
The state is recommending deferred
There's to
adjudication.
be chapter.
There's to be chapter 62 compliance.
And of course, you know there
And
is
of course, you know, there is a registration period related to that of 10 years.
And there is to be no
And there is to be no
contact
contact with the complainant. Do you understand?
Yes, ma'am.
Do you understand that?
Do you understand that to be the entirety of your plea bargain agreement?
Defense, is that the plea?
Defense, is that the plea?
State, is
It
that
is,
the plea?
Judge.
State, is that the plea?
Did you review the waiver?
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places? Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, have there been any such motions? Outside the agreement, the state is requesting that your community supervision be for a term of 2 years and that you be with the sex offender unit. Did you understand those are recommendations from the state, and the court does not have to follow those recommendations? Then to the offense. The lesser included offense. How do you plead? Guilty, not guilty, or no contest? State any evidence.
Yes, Your Honor, this State Officer 6 Exhibit 1 with all attachments.
All right, and state, have you spoken to the complainant or the complainant's family? All right, thank you. You may be excused. Did you review the waiver and consent to stipulations of testimony and stipulations with your attorney? Did you understand it and sign it in all the appropriate places? Again, did you understand? You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call in the right to remain silent. Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence state's exhibits 1 and attachments and review the same. After reviewing state's exhibits 1 and attachments, the court will find there sufficient evidence to find you guilty. Court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
We'd like to, judges.
Anything you wish to say on behalf of your client?
Judge, all I can say is that, as you can see from the nature of the plea bargain, there was a lot of exchanging between the parties of information, mitigation, the history of the case, the issues with the child. Unfortunately, she had a very difficult upbringing, losing a parent very young and didn't have the other parent. It just goes on and on. We went through CPS records, we went through counseling records. And it was a hard decision for Mr. Aliaga to arrive at, but he felt it was in the best interest of himself that he not expose himself to a different kind of an outcome. And he's going to have an extensive registration, which doesn't begin until after the term of probation expires, which is why we had such a long discussion about how long his probation was going to be for. He has a clean record for the most part. He's been gainfully employed, never missed court, never been late to court, has not any violation reports. He's ready to put this case behind him. We do want to address one issue regarding his ability to have access to his grandchildren because of the nature of the case. Obviously, there are restrictions in that regard. The parent of those children is here. If the court needed to hear from him, or he could advise probation in writing what his desires are in that regard. Is that asking for unsupervised? He just wants to be able to see him as he has been their whole lives. Other than that, Judge, we ask the court to follow the plea agreement.